Before we start the program, I would like to give you some housekeeping information. We encourage attendees to use the computer audio for this webinar. Should you experience any audio issues, you can use the optional phone connection which is located on your screen below the webinar slide player. We'll have Q&A during the program live, and you will submit your questions anytime using the Q&A function. After the webinar, please visit the program attendee page to ask additional questions and access a copy of today's webinar. Welcome to Motions to Reopen in Immigration Court, sponsored by the ABA Commission on Immigration. To receive CLE credit, you must attend the entire program. Partial credit is not available. Please click on All Participation Verification Alerts to confirm your attendance. After the program ends, a link to complete the certification process will appear. Please complete the evaluation and the CLE affidavit, providing your bar information as requested, and submit. Once your attendance is verified, your certificate will be emailed to you. Moderating the program today is Emily McCabe. Emily is a senior staff attorney for the Family Group Legal Orientation Program in the American Bar Association's Commission on Immigration. Prior to being at COI, Emily worked for 5 years as an immigration attorney at Northern Virginia Family Service, representing mostly unaccompanied minors, asylum seekers, and survivors of trafficking and criminal activity. In law school, Emily participated in the International Human Rights Law Clinic and volunteered for a week in the American Immigration Lawyers Association pro bono project at the Artesia Family Detention Center, where she conducted consults, filed motions, and represented women and their children in bond hearings and credible fears interview. Emily, please proceed with today's program.
Thank you so much, Nikki. Welcome today. Thank you so much for joining us. And on the program today, we have A. Gregg and Lauren Cusatello. Kevin A. Gregg is the San Diego partner at PA, or KKTP. Kevin practices in all areas of immigration law, including federal court litigation, appellate advocacy, and removal defense. He is also the host of the weekly immigration case law podcast, Immigration Review, available on the KKTP website and all podcast forums. Lauren Cusatello, she, her, ella, is the director of the ABA Immigration Justice Project in San Diego, California, where she started as legal director in 2019. Lauren is admitted to practice before the Executive Office of Immigration Review, California, the United States District Courts for the Eastern and Southern Districts, and the United States Court of Appeals. Notable, where her degree involved legal rules and motions to reopen. The full bios of our wonderful panelists are all available in the materials for today's webinar, and I will now turn it over to Lauren.
Good morning, everybody. All right, so today we're here to talk about motions to reopen, and so let's start by defining what we're talking about. A motion to reopen an immigration removal proceeding is a formal request for the court to reopen the proceedings after a final decision has been made by the immigration judge. And that motion to reopen has to include some new information that was not presented the first time around. This is what distinguishes it from an appeal. It's not about legal or factual errors that were made by the judge. It's asking the judge to consider information that for some reason was not presented. And the legal source of guidance for how to present these that the court provides is, of course, in the practice manual in chapters 5.7 and 5.9. So those are your formal guidance when this is over, in addition to all the materials we've prepared for you. Okay. We see, okay, yes. So motions to reopen, I apologize. The slides were moving a little slowly. Motions to reopen are distinct from motions to reconsider, another form of requesting the judge to take another look. Motions to reopen are based on new information, new evidence that would change the outcome of the original decision, whereas motions to reconsider are based on changes in the law or errors in the law that affected the decision. And motions to reconsider don't involve new evidence when they are standalone motions.
If I may, just real quick on there, with the pleasure to speak and honor to be part of this panel. Thank you for including me, ABA. With the motion to reopen and the motion to reconsider, the regulations tie it to a final order. And so that makes sense with reopening, right? Because you're trying to reopen to do it again. But reconsideration, it's also tied to a final order. Until there is a final order of removal, the proceedings are ongoing, and it's not really for an immigration judge to reconsider his or her prior finding through the strict motion to reconsider requirements. Now, personally, when I file those type things, I do style it as a motion to reconsider. But really, if you're asking an immigration judge to say reconsider whether or not their prior aggravated felony finding was correct in light of a new decision, and if proceedings remain ongoing before that immigration judge, really just kind of like, hey, judge, you messed up. Can you make a different decision? Again, I still style it as a motion to reconsider, but all of these strict deadlines technically don't apply based on my reading of the regulations. So important to remember that these are really tied to final orders of removal.
That's right. And I also call the type of motion you're describing, Kevin, a motion to reconsider. Sort of interim findings that are related to where the case goes moving forward. If we believe that a judge has gotten those incorrect, or sometimes the judge doesn't give you an opportunity to argue something or brief it before making a decision, and surprises you with a decision on an issue. And if you want the judge to reconsider that decision that might preclude relief or something like that, then that's a different kind of motion to reconsider. This is the formal motion to revisit an order of removal or an order denying relief. To file a motion to reopen, there are procedural and substantive requirements. We talked about the requirement to include new evidence, but all of those requirements, which we're not going to cover in detail, the exhaustive list today, they're in the practice manual, in the regulations, and in the statute. But if you start with the practice manual and work your way back, you'll find everything. And there's a separate set of requirements to file a motion to reopen an order of removal that was entered in absentia. And for anyone for whom that concept is new, that's a motion to reopen based not on the merits of the case, but based solely on the fact that the respondent failed to appear for removal proceedings. And so that does result in a final order of removal, but often no facts were considered other than the fact of removability leading to that in absentia order. And so there's a separate set of requirements due to the procedural nature of that kind of order, the fact that there is no appeal, things like that. All of those are contained in Chapter 5.9 of the practice manual. And some important notes that we've included here, the filing fees for a motion to reopen depend on the basis of the actual claim. So whenever a motion to reopen is grounded in an application for asylum, there is no fee to reopen that case. And for example, a motion to reopen an in absentia order based on a lack of notice also does not include a fee. You shouldn't have to pay to reopen an order that was issued against you when the court never gave you notice that you needed to be in court in the first place, right? That's not fair. And it's one of the few places where the system actually recognizes that you shouldn't have to pay to fix their unfairness. There are statutory and regulatory time limits for filing motions to reopen. And there are also what they call numerical limits. As a general rule, a person can only file one motion to reopen a particular removal order. Now, some of you might know the same proceedings sometimes get appealed and remanded back and appealed and remanded back. Each time there is an order of removal, you can file one motion to reopen that one order. So a new proceeding resulting in a new order gives rise to a new right to file one motion. And normally, filing a motion to reopen does not stay the removal of the person filing that motion, with the exception of motions to reopen orders of removal in absentia. Again, this is an order where there's no right to appeal, which would otherwise trigger that stay, and where you're arguing that there was unfairness resulting in the order. This is the only chance you have to revisit that. And so if the person gets removed, it would be quite a bit of work to get them back to actually have the proceedings. And so in that context, a motion to reopen does result in a stay of removal, and we've included the statutory and regulatory sites there. Okay, so let's talk about why you file these, right? We do have a right to appeal any order of removal that's not in absentia. So why would we move to reopen instead of appealing, or why, why might we need to reopen? So the first, and one of the most common, is someone is eligible for a form of relief for which they were not eligible at the time of the hearing. So one common form is a person becomes eligible for adjustment of status who was waiting on a visa of some kind. They did not have a visa available to them at the time of the proceedings, and now they do. And so the person could go back to court and ask to adjust their status based on that available visa. Another is if a person was not competent to proceed in the first place. The person has a serious mental illness. Someone has now discovered that, or the client has disclosed that to someone who says these proceedings should be reopened based on this information that the person really couldn't present to the court on their own, so that the court can first assess this person's competency and then proceed accordingly. A very big one, and one that's got sort of protected status under the statute, is a change in the law or a change in the country conditions. And also in this category is a change in a client's personal circumstances that are affected by that change in country conditions. So for example, if your client is a transgender woman in a country where conditions have gotten worse, perhaps that country has passed a new law criminalizing gender reassignment or being a sexual minority, and that development happened since the hearing concluded and your client was denied asylum or protection at the hearing, you present that new evidence and ask to reopen that application for asylum. And then with respect to your in absentia orders, when client wasn't present and got order removed simply for that reason, without a hearing on the merits of any claims they might have had, if the client did not receive proper notice of the hearing, or if they were unable to attend because they were in state or federal custody when the hearing took place and nobody notified the court of that fact, then that is the basis for reopening an order of removal. And I have seen that happen here in the border region during the previous administration. A program that had existed in other portions of the southwest border called Operation Streamline was developed, where people were arrested for federal immigration crimes at the same time that Border Patrol was processing them for any kind of credible fear or other immigration proceedings. And some of those people were released from federal custody, some of them weren't, but some of those cases had been calendared for court, and folks at times, of course, did not make their hearings because the U.S. Marshals didn't bring them to court, and if they were in federal criminal custody at the time, they could not attend. And so if that was brought to the attention of the court, then those proceedings would be reopened, generally without opposition. So, and that's the easiest kind of inability to attend that a person can prove, because there's generally government records showing where they were at the time of the hearing. Okay, so it is also often the case that there's more than one basis, more than one thing has changed, or more than one piece of additional information has come to light since the hearing concluded. And so if there is more than one ground of new argument or new evidence to raise them all. If it's an in absentia case where you also want to make sure that any applications or forms of relief are identified that someone did not get a chance to identify the first time around, it is a good idea to do that to the extent possible in the motion to reopen as well. And so you want to raise all of those arguments in part because if there's going to be any review in the event that a motion is denied, anything that wasn't presented to the immigration court can't be reviewed by the board or by a federal court. And so it's important to know what actually happened and what was decided in the case the first time around. If you were counsel, you already know, but if you're taking over a case where a person was unrepresented or was represented by other counsel, you want to get the record of proceeding that the court has, get any documents that your client has, and if you're not able to get a relatively thorough record using those methods, then file a Freedom of Information Act request with the court or with USCIS when there are applications that were also filed that you need to look at.
And one of the ways this might work in practice, the multiple grounds for relief on a motion to reopen, and not going to get into it so much because it's pretty detailed on this webinar, but I'm sure many of you know about the whole thing about deficient notices to appear following the Pereira decision from the Supreme Court and Ms. Chavez, and how that's all playing out amongst the circuits and with the BIA. The BIA just issued matter of Fernandez, talking about how a timely assertion of a deficient NTA should result in dismissal of proceedings. Again, not going to get into that here. In my opinion, if you have a final order of removal that you're seeking to reopen for one of the many reasons Lauren is discussing, and if in addition that notice to appear was deficient, to me, that's a no-notice motion to reopen. Whether or not the immigration judge or the BIA will agree is up to them. I think that I've got good arguments for it. I think that is no notice. There is no proper notice of the hearing. The Department of Homeland Security violated the regulations and the statute with the case initiating document. That's important because, as Lauren said, a no-notice motion to reopen invokes the automatic client's removal under the regulations, which when I'm filing such motions, I bold in a footnote on the front page of my motion and then give it to ERO at their OSUP. So, multiple grounds. If you can get in a no-notice argument, and I think deficient NTAs provide that, throw that in. And also, you need to throw those in for all these cases, in my opinion, because all of this is coming down to was it timely asserted. And while there's a lot of case law to say that it is not timely to assert the deficient NTA in the motion to reopen in the first instance, that is not settled case law. So look out for deficient NTAs and make sure you're making those arguments in addition to whatever else you're making.
I think those are great points, Kevin. We have a couple of questions in the chat. We are going to have time for questions at the end, but I'll address a couple of these briefly. So Richard raises a question about new events in the family that add an additional qualifying relative, that there's sort of identified hardship that didn't exist before. Yes, this is new evidence. It doesn't make someone potentially, if they already applied, as you indicated, newly eligible, but it changes the strength of the claim. You do have to argue that the claim would have been decided differently if the judge had this information in front of them, and provide as much evidence as you can, essentially proffer what you are going to prove at the new hearing if the case is reopened. And then there's a question about appeals. So we're not talking a ton about this today, but the funny joke is that all of these things, all of these motions in the same category, they're all motions to R something, right? So it's reopen, reconsider, and then if you file a motion to reopen while an appeal is pending, that is generally considered a motion to remand. That's how the board considers it. So you can file your appeal timely and then file a motion to remand, or you can call it a motion to reopen. But the board has to give jurisdiction back to the court for the court to consider a motion to reopen once there's jurisdiction.
On Rich's point that, I guess a motion to reconsider if you file it, he's right. Then IJ is not going to reconsider their decision in 30 days. Then you're going to have to file an appeal, and then your motion to reconsider becomes moot. That is a flaw in the system. We could send
Yeah, I think most of us have had some success when there's a change in law after we filed a notice of appeal, getting a case remanded back based on that change in law. Certainly I've had that happen when there's a big Ninth Circuit case that changes the sort of decision parameters or that is contrary to the law that the judge relied on. I've had that happen in more than one case where a motion to remand was successful after a notice of appeal had been filed. And it's a strategy call whether you want to go full bore with your appeal or whether you want to lean on that motion to remand as your strategy in the case. But you can do either, you can do both. It's up to the board how they're going to address those things, and a lot of that depends on whether your client is in custody or not. Okay, so in terms of practical pointers, as I mentioned, there is a fee for these if they're not grounded in asylum or a lack of notice. And you file the motion to reopen at the court where the decision was made. So maybe your client is in custody and has been moved to another detention center, or maybe your client's not in custody and had proceedings in one place but is released in another location now. The motion doesn't go to the court where you would like to have the hearing. The motion goes to the court that already had the hearing, and if it's granted, you can move to change venue once there's actually a pending proceeding at the court. So that's where you file, and that's why it's important to actually. You have to attach the order to the motion as well, so you've got to know which court issued the order. And this is just a brief list of the many Ninth Circuit cases that address kind of specific facts related to the adjudication of motions to reopen. And so we've included a recent case involving what's called the departure rule, limiting someone's right to file a motion to reopen after they have departed from the United States. We don't have time to fully flesh out what the rule is or how Ruvalcaba addresses it, but Ruvalcaba actually does have a really good summary of the rule and the case law related to that rule. Castillo is about the weight of expert witness testimony that you might file in connection with a motion to reopen, and Leyva Perez is about stay of removal. So we've discussed all of those things a little bit. Those cases are where to look for sort of longer discussions of each of those topics if they're applicable to a case that you're working on.
So thank you. That was great, Lauren. Thank you so much for all that. Emily, again, and ABA, thank you for inviting me. My name is Kevin A. Gregg, not to be confused with the brilliant Kevin C. Gregg, also based in Southern California. I'm a partner at Kurzban Tetzeli & Pratt and a host of Immigration Review. Hopefully some of you have given it a listen. I'd love to know what you think. See if I'm doing the bar proud. And before I kick it off, I just want to put a link in the chat because with the podcast, I have been giving bullets for every single case discussed, which is every single immigration case from all tribunals that's published. It's like 2,000 cases since May of 2020. And you can do a control find research on the link that I just put in there. And, if you want to find every sua sponte motion to reopen decision decided since May 2020, you can find it by putting in sua sponte or change country conditions, same stuff. So I'm trying to make it in a way that's helpful to me. So hopefully that's a bit helpful. I'm going to just dive deep a bit for this portion of the presentation on asylum motions to reopen and sua sponte, just a little deeper. Obviously, each one of these is its own panel in and of itself. But before I do want to just reiterate a bit of what I said before on these deficient NTA motions to reopen, deficient NTAs, allegations, all of that. I mean, this is where we're at right now, as a lot of you may know. This is the case law is not settled on any area of deficient NTA stuff, except honestly that it's not jurisdictional, but it is a claims processing rule, and it's the same difference in a lot of respects. But what all the courts are saying, I believe a bit unfortunately, is that it has to be timely raised to benefit, even though it would have been denied for 20 years. So make these arguments now, because you will be punished in the future for having not done so. And a lot of it can be done in the motion to reopen context. We're not taught, we didn't dive deep into in absentia motions to reopen. But for example, the seminal cases, there are two seminal cases. One's in the Ninth, one's in the Fifth Circuit. It's Singh in the Ninth, and either, I believe it's Garcia or maybe Gonzalez in the Fifth Circuit, essentially saying that if an individual was ordered removed in absentia and DHS initiated proceedings with a deficient NTA, those proceedings need to be reopened. Now, the Fifth Circuit has walked it back in like 3 decisions, and so it's more complicated in the Fifth, but it's pretty good law in the Ninth. And as you all can gather, the Ninth and the Fifth probably have 90% of in absentia motions to reopen since 1997, or in absentia orders of removal since 97, because those are the border states. So this stuff is huge. How deficient NTAs are going to come into play for motions to reopen. In absentia, without that, it usually requires a showing that the individual properly did not receive notice of their hearing. Again, not this panel. Motions to reopen to apply for asylum, which is probably what a lot of people who deal with the ABA will have based on changed country conditions. These are some of the most favorable motions to reopen because they can be filed at any time. And that's a big deal because half of other motions is kind of arguing about why it's timely, why it should be told, why you can meet the 90 days even though it's been 10 years. And you know, we have the benefit as the private bar of being able to dig deep into country conditions. Some people are from these countries, other people, we have more time than ICE, even though we don't think we do. And we certainly care more than ICE on almost all cases, and that we can use that to our benefit in a changed country condition motion to reopen. Just today, I don't know if some of you saw it, I saw a news report that said the United Nations just had a subcommittee that essentially said Maduro is torturing people. That is new evidence, and that seems material. While a lot of IJs have been granting Venezuelan asylum claims, the CAT and asylum requires government actor, and if the UN is saying that it's coming from Maduro, well, that does seem to be important. And so every day there's something. We got a case reopened from a long-standing removal order from an individual from Azerbaijan because Azerbaijan went to war with Armenia, and we knew it. And we filed that motion within a month. Maybe that motion doesn't get granted today because the war is kind of over, and I'm not going to get into that, but it certainly kind of needed to be granted when we filed it. So timing can be very important. As Lauren said, as with almost all motions, you have to base it on new and previously unavailable evidence. And you can massage that second one a little bit. For example, an expert affidavit, was it previously available? I mean, the expert did exist at the prior hearing, unless they were just born, maybe, and it's been 20 years, but a expert could have existed. But don't forget about those 2 requirements. It's new and previously unavailable. Anybody can get new evidence. And so often the board and IJs will deny this on the previously unavailable prong, even if you have new evidence that wasn't submitted before. But alternatively, if it's going to get denied, it would be on the evidence is not material. Now, I think that's a more difficult denial because the analysis of materiality requires a understanding of what's happening in these countries, and government employees don't always want to do that because they have so many cases. So it's easier to deny on new and previously unavailable, but material is important. And this is what a lot of the BIA decisions will talk about. How do you show that it's material, that it would have changed or it could have changed the outcome? Actually, you see the standard there on that 3rd sub-bullet, matter of SYG. There's a realistic chance that with the new and previously unavailable evidence, they'll be able to establish eligibility. Realistic chance, that's a pretty favorable standard. What does that mean? I have no idea, but it sounds like something I could argue with. Realistic chance. For me, when I do these, you go through all the elements to show its material, to show that this new fact, this new UN report about how Maduro is torturing people satisfies the Convention Against Torture, for example, requiring that the government is the torturer or that they acquiesce or consent. So it is to me, a mini asylum brief with a lower standard. Again, realistic chance standard. When it comes to the actual evidence, I think it's helpful personally that you compare country condition evidence. If the first removal hearing was in 2005, I'll get that State Department report from 2005, and I'll create a chart and put it next to the State Department report in the year that I'm filing the motion, 2022, and show how in each section it has changed. It's pretty hard for a court to deny it when you've put a side-by-side chart like there and thrown it in their face and shown the difference, show how it has materially worsened. We have the time to make these arguments. There's also a lot of good country condition case law out there that I talk about on the podcast, and if you're really looking hard, the Seventh Circuit issued a decision a month ago talking about Ethiopia and Eritrea based on the war there, and pretty much says things have gotten worse in the last 2 years. I mean, forget about doing the analysis myself. If I can show the board that the Seventh Circuit says it's getting worse, who is the board to say it's not? They're not going to deny that motion if you do it right. So using some of this country condition case law to make your country condition argument, I find pretty persuasive.
Kevin,
As
can
with
I jump
all
in here for a
motions,
second?
yeah, please.
Yeah, I want to give a few more examples of the kinds of evidence that can be helpful to get over that hurdle that it's a change and that it's a recent change. One, of course, would be if we've newly designated a country for temporary protected status. Usually the statements that go along with that indicate what's going on in the country that's caused that designation. Secondly, the State Department travel alerts. So if there is a downgrading or upgrading, depending on how you want to think about it, portions of Mexico where a lot of our clients come from have recently been designated do not travel for U.S. citizens. That's a new designation, and they explain why they've changed that status, what's going on. Things that are coming from the government reflecting a change, not just case law, like you mentioned, although case law is great, of course, but especially state or DHS action related to a particular country that reflects their belief that there's a change in the conditions on the ground.
Love the travel alerts because the Department of State is very conservative when it comes to U.S. citizens visiting. All red, don't travel, but you're going to deport people there. So love the travel alerts. To Jose, can you file a motion to reopen for an asylum case that was administratively closed prior to an individual hearing? I think you're in a much better position. You don't need a motion to reopen. You need a motion to recalendar. It's administratively closed. There is no final order. You're in a great situation, it would seem there. You don't have to show any difference. You just need the recalendar. And recalendaring it's kind of standardless, and IJs usually should grant it. So that's a much better situation. Personally, in your motion to recalendar, maybe you talk about how conditions have changed a bit to push the IJ over that hurdle, but no motion to reopen likely necessary there. No, but that brings up the next bullet. Know where you're filing. I mean, if the final decision was in immigration court, the motion to reopen must be filed in immigration court. But if there was an appeal and it wasn't remanded, you have to file with the BIA. If you file with the immigration court when jurisdiction is with the BIA, it's going to get rejected and you might be in trouble as an attorney. You can look and see who last had jurisdiction in EYR's new online system where they show all the case details by putting in the A number. Love that thing. It's actually proof rather than a stupid telephone number. And the non-citizen didn't need to apply for asylum below to file one of these. It could have been a cancellation case, but since in the last 10 years their country has gone to hell, and it could be asylum after that. There's going to be issues if it's an in absentia. It gets tricky. There is case law that says if the underlying was in absentia, you've forfeited the right to apply for asylum, and you need to overcome in absentia before you can apply for asylum, but I don't think that is settled law everywhere. That would require a bit more research. So don't give up hope, even if it's in absentia. With an asylum application, though, and this is another ding, and it's a big ding, you have to include the I-589 with your motion, and that's with any motion to reopen based on new relief. It's a matter of Coelho. But see this Second Circuit case that we cite here, if it's an asylum case previously and you're reopening to again pursue that asylum case based on new evidence, it doesn't appear you need to require a new application, but honestly, that's unsettled. Might as well file a new I-589 just to be safe. Don't want to get dinged. The number, as Lauren was mentioning, generally there is no time or number bar to asylum motions to reopen. They can be filed even if, there's been a lot of, even if they filed 3 previously motion to reopens for new evidence on asylum, you can file a 4th if the evidence is there. However, as we say, the Fifth Circuit is getting a bit cute based on what the statute actually says, which is actually a little terrifying. Don't worry about the Fifth. Don't practice on the Fifth if you don't have to. And, that is one case recent in the Fifth. But generally, there is no number bar. Adverse credibility is this is a bit of an issue, though, based on matter of FSN from the BIA. If the non-citizen was previously found not credible for any reason, and now they're filing a motion to reopen based on objectively worse country conditions in their country, they still might have to overcome the adverse credibility finding with new and previously unavailable evidence to apply for asylum. Now, if it is objective, if, for example, you have, just gonna make it up, if it's objective, if they're clearly newly eligible for relief because terrible things have happened and it's affecting all people objectively like them in the country, you might be able to get over matter of FSN without attacking credibility. But matter of FSN is making it difficult. If there's a prior adverse credibility, you might have to show actually this new evidence shows that this person is a credible person. But I've also used that to flip. If the BIA is saying that when you're not credible, it's going to be more difficult to reopen to apply for asylum, doesn't that mean that when they were previously found credible, it is not as difficult to reopen to apply for asylum because this is a credible witness? I think that that's a good argument. I've been making it. So, there's double-edged swords for all these. Know your burdens, and then I'll get off asylum. If, for example, in the prior asylum application 10 years ago, the immigration judge found that they had suffered past persecution, but that ICE had established that they could reasonably relocate, and that's why they lost. Well, in your motion to reopen, you've already got past persecution. You're just trying to show that there's new, previously unavailable material evidence showing that your client cannot reasonably relocate. So these are mini asylum cases under the guise of a motion to reopen, and it's fun stuff. Then going to sua sponte, it's kind of the hodgepodge of everything else that's not an asylum or in absentia type motion to reopen. And there's case law out there that says a sua sponte motion to reopen, it's not even a motion to reopen because it's the court or the BIA doing it on its own. But of course, no one is in immigration court looking at all 10 million cases to say, should we reopen this? Should we reopen this? So it comes under the guise of a sua sponte motion to reopen. The regulations permit an IJ or the BIA to reopen proceedings at any time on their own motion without limit. The prior administration tried to fix that reg to prevent sua sponte motions to reopen, but thankfully those new regs have been enjoined, and hopefully the current administration promulgates new regs on that. But as we currently stand, IJ's BIA can reopen for any reason, but there is case law out there from the BIA that says, yes, they can do it for any reason, but it's usually going to be based on extraordinary, exceptional reasons to reopen sua sponte. Personally, I almost always throw a sua sponte section into my motion to reopen. Rarely am I only filing a sua sponte motion to reopen. It's usually an alternative way, and I'm throwing the kitchen sink in it. And if nothing else, I'm using that section to show, hey, judge, this person's a really good person. They're newly eligible for relief. They're now eligible for an I-130, for adjustment of status based on an approved I-130. That also might be a motion to reopen based on new evidence with a new application for relief with a request to toll the 90-day filing deadline, maybe. But it's also a sua sponte request in the alternative. And in that sua sponte section, again, that's where I can show the IJ that this person's a great person and they deserve this extraordinary second chance. Judges are people too. And if nothing else, you haven't waived the sua sponte argument. It's the kitchen sink. It's a new eligibility for relief that's kind of overlapping with the statutory regulatory motion to reopen. Fundamental changes of law. This is almost always going to be under the guise of a sua sponte motion to reopen. If, for example, your client was ordered removed because their California burglary under Section 459 was an aggravated felony, well, in 2016, the Supreme Court said in DeMaia, no, it's not under 16B. The Ninth Circuit said it previously. If you're in the Ninth Circuit, when should you have filed that motion? Actually, there's a Ninth Circuit decision that said you should have filed it after the Ninth Circuit said it and not waited for the Supreme Court. So you got to be updated on your case law. Listen to Immigration Review podcast. That was a joke. But the fundamental change of law, these things change all the time. What is fundamental? That's often where a lot of the argument happens. Is DeMaia a fundamental change of law? It's actually not clear because 18 U.S.C. Section 16B analysis changes over time. Again, with sua sponte, because it's not even really a motion to reopen, there's no number or time limitation. Again, the Fifth Circuit's getting cute. And generally, the circuits cannot review a denial of a sua sponte motion to reopen after the BIA, but there are exceptions. For example, if the BIA were to say, we're not going to grant this sua sponte motion to reopen because we cannot grant the sua sponte motion to reopen just because a person has become adjustment of status eligible, that would be an incorrect legal conclusion that a circuit could review. But that's getting pretty into the weeds. So that's the end of my section on sua sponte and change country condition motions to reopen. And I don't know if you have anything to jump in, Lauren, or answer some of these questions. And again, it's a privilege to be here.
Yeah, great information, Kevin. I will add, there's really no downside to including a sua sponte request with every motion to reopen or reconsider, because if there are issues related to time or number, or or if you're asking for something that the court maybe doesn't want to do, like tolling, and by tolling we just mean essentially pausing the deadline because it was not possible to file something timely. They don't like to grant tolling. When they want to grant an untimely motion, they'll usually do it sua sponte. So if you include that request, they can do it whether you include it or not. But once you include it, again, you do have something that potentially could be reviewed if they deny it based on incorrect conclusions of law. So that's the other good reason to include it. But let's I guess get to some of these questions. Okay, so there's a couple about in absentias. I guess let's start there. So if someone was kidnapped and couldn't go to their removal hearing because they were kidnapped in Mexico, I think there's a fair argument that that is an extraordinary circumstance that would justify a motion to reopen and rescind an in absentia order. It would have to be timely unless something related to the kidnapping prevented it from being filed timely, in which case you would have to argue that the deadline should be told if the person were hospitalized or were still sort of in the custody of the kidnappers or something like that. But yes, that would be a good ground for a motion to reopen an in absentia. And
let's do this rapid fire. This is actually kind of fun. A whole lots of different questions here. It's
how can you request the ROP? So you can do it by email now. Each court has an email box to request. If you were counsel before, then it should not be a problem. I don't know how the various courts are treating the privacy waiver question with respect to ROP requests. My guess is you do have to submit a privacy waiver or a G28 if you were not counsel underneath. But you request it directly from the clerk of the court that you're looking at. If it's a really old record, you'll probably have to file a Freedom of Information Act request. But if it is something that would be timely, And now, anything new is going to be on the electronic case system. And so prior counsel should be able to get it if there was counsel, and the clerk should be able to get it for you if not.
That email address is fantastic. It really is. I've gotten quite a few in only a matter of days compared to the year and a half with an EOIR FOIA. But there's also a new EOIR FOIA portal. Just know with requesting an ROP, you might have to move to reopen and substitute as counsel. It gets a bit confusing if there was prior counsel, but maybe not. I'll take one as you look at another one, Lauren, if you don't mind. The final order of removal that is not executed, the respondent has never departed the U.S. It's not a barrier to adjustment of status if now eligible and no need to reopen, right? It depends. That is the wonderful answer. If the individual is designated an arriving alien in the notice to appear, USCIS will have jurisdiction over an arriving alien adjustment of status application, and then you should be able to adjust before USCIS with an I-212 waiver of that. You'll still need a waiver for that unexecuted final order removal. Also, USCIS might have a policy of denying as a matter of discretion where there is an unexecuted removal order, but again, that's also kind of what the waiver is for. However, if you don't have an arriving alien client, if they were iwi, or if they were admitted, that final order of removal will most likely need to be reopened because USCIS will take the position that it does not have jurisdiction to adjust your client where there is an unexecuted final order of removal against a non-arriving alien non-citizen. So it gets really complicated. But use that in your motion to reopen. Be like, Judge, we can't do this unless you reopen. Obviously, it's a much better motion than that, but that's a factor. So that's a complicated area right there, and it gets even more complicated if the final order was an ICE expedited removal order. Where to file the motion to reopen? I think you got to file it with ICE. But just to take one more, if filing a motion to reopen based on new eligibility to adjust, must you file the entire 45 packet with the motion, even an I-693? No, not the I-693. Definitely the I-45, that's matter of Coelho. Read matter of Coelho, don't take what Lauren and I are saying at all. But generally it's just the application. But Coelho is more to establish prima facie eligibility for relief. That's the standard. Does a 45 just establish prima facie? Maybe, maybe not. You already got the client. You can, I submit, maybe not everything, but again, I'm trying to paint the whole picture for the board or the IJ to distinguish my case from the thousands of others that are coming across their desk to show this is a good person. You're going to have to produce it anyway. Why not produce it with the motion to reopen stage? And again, but prima facie eligibility is your standard. And so an application will not always necessarily establish that.
We have a couple of questions here related to the removal in absentia of minor children. The first is, how would you analyze doing that? And the second is, can the fee be waived? The fee can be waived for anybody for a motion to reopen with a fee waiver request. And in some cases, there is no fee, as we mentioned. So, if it was an asylum case in the first instance, there is no fee. If it's a motion to reopen in absentia because the children did not get notice, again, there's no fee for that. So you might not even need a waiver. It is really good practice to put sort of in all caps, highlighted, underlined, no fee required pursuant to, and identify the correct section of the regulations that says that no fee is required, because a clerk will reject it if they don't know why you haven't attached a fee. And that way you don't run into timeliness issues if it's otherwise timely, or and the time bar would apply. In terms of minor children, I will give a few answers to this. There's a lot you can say. If you're talking about minors whose cases were consolidated with a parent or guardian, and the parent or guardian did go to court and the minors didn't, I mean, of course, if there were extraordinary circumstances that led to that happening, then that would be part of it. If the children were unaccompanied and were in the custody of the Office of Refugee Resettlement or were in a guardian's custody, again, making sure that whoever had custody of the minors actually did receive notice of the hearings. And that goes back as well to Kevin's argument about notices to appear. So if the initial notice to appear did not include a time, date, or a place as the statute requires, here in the Ninth Circuit we have this great case Singh saying that minor is entitled to any, even a non-minor is entitled to reopen a case where they were never given the notice required by statute, even if they received a subsequent hearing notice with the date and time of a hearing. And so if that applies in your case, which it does in most, that would be another basis. That those are the main arguments that come to my mind. Kevin, anything else you can think of that's specific to minors?
So and I see that someone might have had difficulty hearing me because of some feedback. I hope that's not still happening. I've turned down the volume on my end. Hopefully it's coming in clear, fine. No, that's great with minors. I mean, there's other case law, then the regulations require special service upon minors. But that doesn't necessarily apply if they are a derivative or a secondary respondent in proceedings. But there are regulations requiring special things for service upon minors below the age of 14, I believe. And so that would create other arguments for an in absentia with a minor. But also, again, judges are people too. I mean, make your case, but who wants to punish a kid? Even no matter what you think about IJs, I think that many of them can understand. The individual who said that she couldn't hear what I was saying was actually the individual who asked about the reopening when there's an unexecuted final order. So I hope you heard what I said. But to summarize again, the answer to that question will depend on whether or not the non-citizen was classified as an arriving alien at the time of the removal hearing.
Okay, so let's talk about requesting an ROP for someone who was ordered removed and then re-NTA'd. So I don't know if we're talking about someone who has been removed and re-entered or somebody who has remained and for some reason there has been a new notice to appear. With a Freedom of Information Act request and probably with the court as well, the way they maintained the files when it was all paper was, everybody just has one giant file. Sometimes it gets into multiple red wells worth of file, depending on how many proceedings they've had. They generally create a new paper physical file for each proceeding, but they keep them all together under the A number. And so if you're looking for a prior proceeding and you want to make sure you get that, indicate the dates and courts where, even if it's just a time frame, you might, you should have the date of removal if you're, or the rough time frame of removal. But you might just say, I want the 1992 proceedings from the Chicago Immigration Court. And then they'll know, oh, you want the old ROP. And sometimes that's as specific as you can get. Okay, and then I think, case remanded. Case has been remanded. Can I rely on the exhibits in the original proceeding? I think you should. That's the kind of thing, now that we've got these pre-hearing conferences that EOR is endorsing, that would be a great thing to address at a pre-hearing conference, just confirming that we've all got the same set of exhibits. But if not, and you've got the ROP, of course you could resubmit them. Different judges kind of treat this differently, though. It partly depends on the nature of the remand order. If it's remanded with instructions to, reconsider in light of additional country conditions evidence, then it should be consider all the evidence that was already in the record plus the new evidence. But if it was remanded to consider a brand new application, then the evidence that's in the record already might not be relevant, or it depends. Okay. And then the
I
next
see
question
another
we
one
have is,
about cancellation. I'm sorry, what was that?
oh
Just
no, go
while you
ahead.
look, I see another one about cancellation. Someone asking about a suicide attempt for a qualifying relative for cancellation that happens after the hearing during a BIA appeal of a cancellation denial. That if the BIA appeal is pending, that's actually not a motion to reopen because there is no final order of removal. The final order, if there's an appeal, only happens after the BIA issues a decision. So if the appeal is pending, that's a motion to remand. The standard pretty much the same. At least that's how I do it. I always err on the sides of difficult standards, and then I meet them, so there can be no gotcha on the standard. But I mean, a motion to remand, you'd have to show that, like, just to reopen, there's new, previously unavailable material evidence, in this case of cancellation eligibility. And if the only denial was that the hardship wasn't sufficiently exceptional and extremely unusual enough, well, there you go, and you might be able to show your realistic chance of succeeding. But in that circumstance, you wouldn't have any number or time bar because there is no final order. It's just a motion to remand. And so that's really all about materiality and throwing it at the record to show, hey, BIA, things are different now. Give us a shot to make our case. And this wasn't our fault. This happened afterwards.
Great. And looking at Corey's question about a 20-year-old in absentia order. So, do we wait for someone to have a current priority date to take advantage of a settlement that would allow adjustment? This is really two separate questions. A person with an in absentia order has an in absentia order. That for that to get reopened, you're going to have to make the showing that that they did not receive proper notice, basically. 20 years ago. Now, if the person is otherwise eligible to adjust, then you don't have to worry about the old removal order. So, if you need the order reopened for the person to be adjustment eligible even with the current visa, then you need to have the grounds you would otherwise have to reopen an in absentia order. But you don't need to. If you don't need to reopen, then you proceed with your adjustment pursuant to a settlement the same way you would without an order. It just depends on the effect of the order on any particular adjustment. Does that sound right to you, Kevin? This is a slightly complicated fact pattern here, so.
Yeah, no, it is, and unfortunately, I'm not familiar enough with the CARESEN settlement. But so for the first part, though, I mean, generally for adjustment eligibility, you should probably wait for the visa to become available, unless you can get DHS to join in on your motion and make it a joint motion, which we didn't really get into. But now is the time. Who knows what's going to happen in 2024? Be reaching out to DHS to get them to agree to joint motions to reopen on long pending cases before the BIA. Because those can happen now, and you don't want to be in sua sponte territory if you've got ICE agreeing to non-op or to even join on the motion. There is a follow-up about the question, do you need to reopen with an unexecuted order of removal? You do need to reopen that unexecuted final order of removal to adjust LPR status if the client is not an arriving alien, if they are iwi or if they were admitted, because USCIS will take the position that they don't have jurisdiction unless the removal order has been executed. So you have no forum to apply to adjust status but for reopening. If it's an arriving alien, then USCIS does have jurisdiction. You probably need a waiver for that final order of removal. Stuff does get pretty complicated there.
So
must Chief Counsel
we see a question.
always provide me with what
Yeah.
must Chief Counsel always provide me with what they provide to the BIA on appeal? Damn right they must. I mean, in their filing. I mean, I guess not, right? If it's your appeal, then ICE can file their response, and if they're providing new evidence, that's on them, and I'd file a motion to strike because you're not allowed to provide new evidence on appeal. If it's ICE's appeal and they're providing new evidence with their appeal, again, that they're not allowed to do that unless they're moving for a remand. So really, it's a motion to strike no matter what. ICE must provide you whatever they're relying on, but whether or not the BIA should be considering it, I guess, is a separate question.
Services
Is there
in
an
the
argument
practice
that travel
manual.
on,
What's
is there an
that?
argument that travel on TPS advance parole executes a removal order? I'm not getting into that one. That's
Yeah.
the Supreme Court decision 2 terms ago. New stuff from USCIS is a very complicated question, but honestly, you know what? Not getting into it. But advanced parole with TPS now under USCIS policy, removal order or not.
You don't need advanced parole. They've got their own special category of TPS
Yeah.
power. So
But
you
if
are admitted if
removal
you,
order or not,
yeah.
yeah, you're not doing it. Not doing it.
All right.
It's a good question and look into it.
Let's answer Rachel's question before we let everyone go. So someone who got proper notice but appeared the wrong day, and that was 2 weeks ago. So they're timely for a motion to reopen. So I mean, I have a lot of follow-up questions, but I'll address them as quickly as I can. The first is, if you were counsel or a colleague was counsel for this person, was there some way in which you all failed to effectively ensure that your client appeared for court? If this person showed up at your office 2 weeks after this happened and was unrepresented by counsel at the hearing that they missed by a day, when we say general confusion and honest mistake, is there some deeper mental health or physical health issue that might have led to that? Someone's individual hearing is a pretty big deal. They got written notice, they got oral notice, they can check in any number of places. What do we mean by general confusion and honest mistake? And when we say proper notice, again, is this really I haven't seen very many sufficient NTAs. And so you don't just look at that hearing notice, you look at the charging document. If that initial charging document did not include a date and time and place, you can argue that depending on where you are, either the court is bound by Singh to reopen this proceeding because they were served with what we call the purported NTA, right? They were served with the purported NTA, but it doesn't comply with the statute, and therefore they couldn't have been properly ordered removed in absentia because they didn't receive proper statutory notice. And then you have some of the other sort of tricky notice arguments that we didn't get into, like, did the department actually establish removability before the order was entered? Things like that go to the sufficiency of an order in absentia. There might not actually be a valid in absentia order if that didn't happen. You can't just order people removed just because they didn't show up. They have to be removable, right? So, if you have any other kind of creative arguments on behalf of this person, but I would really get into what we're calling the honest mistake here, because it's a pretty big deal to get the date of your hearing wrong, especially if you are represented by counsel. Something went wrong there that we would want to explore, right? So that's my answer. He was pro se. Yeah. Yeah. I mean, just find out. You've got a witness too. Like that's a lot. Because that person would have had to be told in advance about the hearing. And again, usually clients rely on the paper they get from the judge to do that. So, okay. We answer this last one. If the BIA denies remand and affirms a removal order while you have a PD request pending, is it worth trying a motion to reopen? Well, it would have to be something new after the BIA decision at that point. If you're talking about the thing they denied remand for, that's already been presented to them, and so then you'd be in the motion to reconsider territory, or potentially, motion to remand is just how we style what would otherwise be considered a motion to reopen or reconsider. So that's something that would probably be more likely to go into a federal petition for review at that stage. If OPLA indicates willingness to give PD, well, if OPLA wants to reopen the case, then you're good. If that's the kind of PD that they're willing to, I mean, I assume whatever PD they were willing to grant included administratively closing or terminating the case or stipulating to a grant of relief. Those are kind of the big three. So if they're willing to do one of those things, I hope they're willing to agree to reopen the case to do whatever it is that they've agreed to do, because they can reopen whenever they want. We didn't talk about that, but joint motions to reopen are, the golden ticket. So I think that's it. I know we're over. Thank you all for your time and for getting interested in this complicated but really important area of law, especially considering we've been running a system that has thousands of respondents in another country for a lot of the process for years now. It's really important to have folks dedicate time to these, especially now that we're getting some good case law. I know we've got the Fifth Circuit being cute, but we've got the Ninth Circuit being beautiful. So, take advantage. Like Kevin said, jump into this notice hole and get as many of these reopened as you can, because then it's just a clean slate. You might have the evidence that's already in the record, but other than that, you can make whatever arguments you want and present whatever you want within the scope of the reopened proceedings. So buying someone a second or third or fourth or fifth chance. So thank you so much.
Thanks for having me again, ABA. Thank you all for listening. It was an honor. I put my email into the public feed here and that link for you to look into cases if you're interested. And thank you for having me. Hopefully this was helpful.
Thanks, Kevin.
Of the ABA, thank you, Lauren and Kevin, so much for sharing your expertise with us. And for folks who are interested in MCLE, if you could just hang.
Thank you. On behalf of the American Bar Association and the ABA Commission on Immigration, thank you for participating in this program. To learn more about the sponsors, visit the ABA website at americanbar.org. Thank you, and please click on the evaluation link as we value your feedback. For those of you who want CLE credit, please click on the link now appearing in the presentation window. This will open the program evaluation, and after you submit the evaluation, the attendance confirmation form and request for CLE credit will appear. Please complete the information requested on the form and submit. Your information will be verified, and if your attendance meets all the requirements for CLE credit, your certificate will be emailed to you.